Tonight, we witness something that rarely happens in American federal courts, something that legal professionals spend entire careers preparing for but hope never to see. A moment when the authority of the judiciary collided head-on with the defiance of a former president. And what happened in those minutes will be studied in law schools, debated in legal circles, and referenced in courtrooms for years to come. This was not a routine contempt warning. This was not a procedural formality. This was a federal judge exercising the full weight of judicial authority in real time on the record, with consequences that could have included immediate incarceration. And the person on the receiving end of that authority was Donald Trump. What unfolded today in federal court was both predictable and unprecedented. Predictable because Trump's courtroom behavior has followed a pattern for months. Unprecedented because no former president in modern American history has come this close to being physically removed from his own trial and held in a cell during active proceedings. Let's be clear about what happened and why it matters. The buildup. For weeks, federal prosecutors and court observers had been watching Trump's demeanor. In criminal trials, defendants communicate through patterns. Some patterns are obvious: public attacks on social media, inflammatory statements outside the courthouse, coordinated messaging through their legal team. Other patterns are quieter but just as telling: changes in body language during testimony, sudden strategy sessions with counsel, shifts in tone when addressing the bench. What worried court watchers in the days leading up to today's confrontation was not that Trump was being confrontational, it was that he had gone silent. The Truth Social posts slowed. The hallway interviews became shorter. The courtroom posture became more rigid. Experienced trial attorneys know what this means. It means something is being planned. It means a defendant is no longer reacting. They are calculating. Judge Arthur Engoron's chambers had reportedly received signals, not formal motions, just quiet indications from court staff and security that Trump's legal team was preparing for something disruptive. These signals are part of the invisible infrastructure of federal trials. Bailiffs notice things, court reporters pick up on tone shifts, prosecutors sense when defense strategies are about to pivot. By Tuesday morning, those signals had become impossible to ignore. Trump's attorneys held an unscheduled conference call at 7 in the morning. Court security was briefed on protocols for potential disruptions. The prosecution team arrived an hour earlier than usual. None of this was coincidental. Everyone in that building knew something was about to break. The moment. It happened at 10:47 a.m. Eastern Time. The prosecution was questioning a forensic accountant about financial disclosures. Standard testimony, methodical, technical. The kind of evidence that builds a case brick by brick. Trump had been sitting quietly at the defense table, arms folded, expression unreadable. And then he spoke, not to his attorney, not in a whisper, loud enough for the entire courtroom to hear. That's a lie. The room stopped. The witness paused mid-sentence. The prosecutor looked toward the bench. Judge Engoron's head came up from his notes. Trump's lead attorney, Alina Habba, immediately reached for his arm. But Trump continued, "Complete lie. Everyone knows it." This was not a slip. This was not an emotional outburst. This was a deliberate challenge to courtroom procedure, and Judge Engoron recognized it instantly. His response was immediate and unambiguous. "Mr. Trump, you will remain silent or I will have you removed from this courtroom." That warning should have been enough. In most federal trials, it would have been. Defendants, even powerful ones, understand that a judge's warning carries enforceable consequences. But Trump's response was something legal analysts say they have never witnessed in a case of this magnitude. According to multiple sources present in the courtroom, Trump leaned forward and said, "You don't have the guts." The air in that courtroom changed. Court staff who have worked in federal buildings for decades described the tension as unlike anything they had experienced, because what Trump had just done was not merely disrespectful. It was a direct test of judicial authority, a challenge to the foundational principle that judges, not defendants, control courtrooms. Judge Engoron did not hesitate. "Mr. Trump, I am now holding you in contempt. You will either sit quietly or you will be escorted to a holding cell for the remainder of today's proceedings." The escalation. What happened next is now part of the official court record. Trump muttered audibly, "This is a kangaroo court." Judge Engoron issued a second warning. Trump stood from his chair. The judge's voice cut through the room. "Sit down, Mr. Trump. Sit down now, or you will be physically removed and held in contempt with penalties including potential incarceration." That word, incarceration, was not rhetorical. Federal judges do not use that term lightly. It is a specific legal threat backed by centuries of common law and statutory authority. When a judge says incarceration in open court, it means holding cells, bailiffs, and immediate physical custody. Trump's attorneys immediately requested a sidebar. The judge granted it. For 11 minutes, lawyers huddled at the bench while Trump sat at the defense table, visibly agitated. Witnesses in the gallery reported that he crossed his arms, set his jaw, and stared straight ahead. When the sidebar ended, Alina Habba returned and spoke to him in urgent, quiet tones. He shook his head. She spoke again. He looked away. Finally, she placed her hand on his shoulder and said something that made him sit back. In other words, Trump's own legal team had to physically and verbally intervene to prevent their client from being taken into custody during his own trial. This is what makes today's events so significant. This was not theater. This was not a political stunt. This was a federal judge prepared to enforce contempt powers against a former president in real time. Why this matters. Federal contempt authority is one of the most powerful tools a judge possesses. It allows immediate sanction without jury deliberation, without appellate review, without procedural delay. When a judge holds someone in contempt, that person can be jailed on the spot. The authority exists to protect the integrity of judicial proceedings and to ensure that courtrooms remain spaces where law, not power, prevails. Judge Engoron's response today demonstrated something crucial. He was not reacting emotionally. He was not grandstanding. He was applying established legal principles with precision. Every warning he issued was grounded in statute. Every threat he made was enforceable. Every word he spoke was designed to preserve the trial's integrity. Legal experts monitoring the proceedings have noted that Judge Engoron's handling of the situation was textbook judicial crisis management. He did not escalate unnecessarily. He did not allow the disruption to derail testimony. He gave Trump multiple opportunities to comply. And when compliance did not occur, he made clear that consequences were immediate and non-negotiable. This matters because it shows that the federal judiciary is prepared to enforce its own authority even when that authority is challenged by someone who once held the highest office in the land. The rule of law depends on this principle. Courts must be able to function without intimidation. Judges must be able to control their courtrooms. Defendants must understand that their status, wealth, or political influence does not exempt them from the same rules that apply to everyone else, the broader strategy. Legal analysts are now debating whether Trump's outburst was impulsive or calculated. Some believe it was a provocation designed to create grounds for mistrial or appeal. Others think it was genuine frustration boiling over under the weight of damaging testimony. A third group suggests it was a performance intended for his political base, a way to frame himself as a victim of judicial overreach. All three explanations may be partially true. Trump operates on multiple levels simultaneously. He is a defendant managing legal jeopardy. He is a political figure managing public perception. He is a strategist testing the boundaries of institutional authority. Today's confrontation served all three purposes. But here's what legal experts are watching closely. Trump's behavior today was not isolated. During the lunch recess, he posted attacks on Judge Engoron on Truth Social. His legal team filed motions questioning the judge's impartiality. Outside the courthouse, he called the trial a disgrace. All of this happened within a 6-hour window. When a defendant engages in simultaneous attacks across multiple platforms, it signals coordination, it signals a broader strategy, and it raises questions about what comes next. Is Trump preparing to boycott future proceedings? Is he attempting to provoke a mistrial? Is he testing whether he can create enough chaos to destabilize the trial itself? Judge Engoron's response today took that option off the table. He did not issue vague warnings. He did not defer enforcement. He made a direct, legally binding threat: behave or face incarceration. That clarity is essential because it removes ambiguity. Trump now knows exactly where the line is and exactly what happens if he crosses it again. What comes next? Tomorrow morning, the trial resumes. The same judge will preside, the same prosecutors will present evidence, and Donald Trump will sit at the same defense table. But the dynamic has shifted. Judge Engoron has demonstrated that he will enforce courtroom rules without hesitation. Trump has learned that judicial authority in a federal courtroom is not negotiable. Legal observers are monitoring several key indicators. Will Trump comply with courtroom decorum going forward? Will his attorneys file emergency motions seeking recusal or mistrial? Will Trump's public statements escalate or quiet down? Each of these indicators will tell us whether today's confrontation was a turning point toward compliance or the beginning of a more sustained conflict. What we know for certain is this: Judge Engoron is prepared. His responses today were measured, precise, and grounded in law. He did not overreact. He did not back down. He exercised judicial authority exactly as it is designed to be exercised, calmly, firmly, and with full awareness of the consequences. The courtroom held, the judge stood firm, and the rule of law proved, once again, that it applies to everyone, no matter their title, no matter their power, no matter their past. This story is not over, but tonight, one principle stands clear. In American courts, judges have authority, and that authority, when exercised with integrity and precision, is stronger than any individual who tests it